It's not just enough for America to say that George Floyd's life matters. We have to show that George Floyd's life matters by our actions. It's not just enough for America to say that Black Lives Matter. We have to show that Black Lives Matter by our actions.
That was Benjamin Crump, the attorney for the family of George Floyd, speaking after news of a $27 million civil settlement against the city of Minneapolis and those 4 former police officers involved in the death of George Floyd last May. The settlement is one of the largest in a case of police misconduct ever. It comes as jury selection continues in the trial of Derek Chauvin, the police officer who held his knee on George Floyd's neck for those seemingly endless nearly 9 minutes. So far, 7 people have been seated on the jury, with opening statements planned to start at the end of the month. The jurors will deliberate an additional charge now against Chauvin after the judge announced yesterday that he will allow prosecutors to add third-degree murder, along with the more serious charges of second-degree murder and second-degree manslaughter Chauvin's already facing. Joining our conversation, Reverend Al Sharpton, host of MSNBC's Politics Nation and president of the National Action Network, and former prosecutor and civil rights attorney David Henderson. David's representing the family of a woman killed by police in Fort Worth, Texas. That family is suing both the city and the officer involved there as well. I want to start with you, though, Rev, because you have been a part of this. You've been with this family, and I wonder how they feel about the settlement today.
Well, we have been talking all week. Phalonis, the brother, and I, Attorney Crump and others, and I knew the settlement was upon us. I chose not to go because none of the civil rights groups, including National Action Network and others, want any part of the settlement. And people would try to say we were there getting some of the money. Even when we pay for funerals and all, we don't want reimbursement. This should go to the family. The removal of George Floyd's life, who had children and a grandchild, and the value of his life, the city owes that. These officers were working on the payroll of the city. They had a badge and a gun from the city. So the city owed that. But it doesn't end there. One has nothing to do with the other in terms of the criminal justice of the matter. And the family has made it clear they can give us all the money in the world. We want these police to pay for the crime, not just the city pay us off. We cannot set a precedent that you pay for the right to kill us, but you ought to pay for the damages that you do cause.
So on that note, Rev, can you just speak to the significance of a judge allowing the additional charge of third-degree murder?
I think that it is significant in the sense that it now gives the jury in the trial 3 options, criminal options, on the defendant officer Chauvin, who had, in fact, in my judgment, lynched George Floyd with his knee. They can convict him for murder 2, they can convict him for murder 3, or they can convict him for manslaughter or 2 of the above or 3 of the above. I'm sure the attorney can correct me on that. I'm not a lawyer, but I do know the options are important because I've been in enough of these cases for decades where people have gotten away where people say, well, they overcharged them. I didn't think it reached that bar, but it would have reached this. I don't think this jury has no way out of coming out dealing with these charges when the whole world saw for almost 9 minutes this officer put his knee on George Floyd's neck. Even if you want to argue, as the defense probably will, he was operating in a moment of anger or he was trying to restrain him. At what point in 8 minutes and 46 seconds does it turn into willful intent? Which is why when I did the eulogy at George Floyd's funeral, I had people stand up for 8 minutes and 46 seconds to realize how long that was. Somewhere along the line, with this man begging for his life, this officer should have released his knee. He didn't, and he ought to be criminally held accountable for it, in my opinion.
David, can you just pull the curtain back on the prosecutorial strategy? Rev, we're going to get your shot back. We lost your picture a little bit, but we heard you loud and clear. Just speak to what the Rev is alluding to, that the prosecutors now will be presenting jurors with 3 options at the end of presenting evidence.
Absolutely. The most important aspect of the third-degree murder charge being added back in, which I think was foreseeable if you read the Court of Appeals opinion, is that the prosecutors originally started with this charge, and that lets you know it's the charge that they actually believe in, which goes a long way when you're actually in court. Based on the way they've handled this so far, my concern is with whether or not their hearts are in this case and whether or not they see the potential of this case. This case has the potential to help people heal. It has the potential to help the community in Minneapolis heal. It has the opportunity to help our nation heal. It also has the opportunity to help the Floyd family heal if the case is handled in the right way. But the tone that I've seen from them so far and what I've noticed in some of their briefing makes me concerned about whether or not that is the case.
I want to hear more about your concern about their heart being in it. And I want to read you something from the AP about a juror being dismissed. The Associated Press is reporting that a woman, a recent college graduate, said she had seen bystander video of Floyd's arrest and closely read news coverage of the case. In response to a jury pool questionnaire, she said she had a somewhat negative view of the officer, Derek Chauvin, and that she thought he held his knee on Floyd's neck for too long. I could only watch part of the video, and from what I saw as a human, that did not give me a good impression, she said. She said she did not watch the bystander video in its entirety because I just couldn't watch it anymore.
So part of the concern when you go into a case and you've got a jury is that you have to realize that juries tend not to sympathize with the person at the center of the trial as much as you would like to as a lawyer. That's one of the hardest things to learn when you're getting started trying cases. Juries tend to make decisions based on whether or not they feel safe and secure. That's part of the reason why it's important to have a diverse jury, and I'll be more specific. When this case started, I think that you need to have 2 Black people on that jury panel in order to have a good chance of success. Based on what I've seen through this trial so far, I'm going to increase that number to 3, and that's based on what we've seen in other cases. Regarding where the prosecution's heart is, in their motion to try to stay these proceedings on page 4, they refer to this process as, quote, the Anglo-American tradition of criminal justice. I know what Anglo-American means, but I have to ask the question, the legal team that thought that was the right way to describe this process, how in touch are they with what's actually at stake in this case? And that goes to their ability, for example, to rehabilitate jurors like the one that you just mentioned in order to make sure that the jury panel actually reflects people who have the ability to make the right decision on this case.
Thank you.
Thank you.
Thank you.
Thank you very much.
Thank all of you out there.
Thank you as always.
Thanks to at home.
Thanks for watching.
Thank you so much for letting us into your homes during these extraordinary times.